Okay, why don't we all get in our seats here and get started? Oh, you know what? I'm missing my.
Do you have an extra pair? No.
All right. First one up, Senate Bill 47, health insurance policies for the birth of the mom. Okay. This is a insurance department bill, is that right? Yeah. Okay. Any amendments? Anything needs to be done to this bill? It's all good? Okay. No. Anybody in the room has a problem with this bill? What's going to it? Is anybody here wants to see this bill passed? Okay, other than the department people. So all the rest of you here are obviously not for this bill. Okay. Right. I'll just wait till my clerk gets back. Yay. She says she can't find her glasses. So who's on the health insurance? And we get the right. Be sure we get the
Let
right.
me get the committee thing out.
Okay.
All right. Here we go. Insurance, Porcelli, Miles, Hunt, Daxton, Teresia, and Gibbs.
Did you say me?
Yep,
I would.
you had
Yeah,
moved,
yeah.
moved people in
You're-
and out, so,
you're on.
okay.
And okay, so
1, 2, 3, 4, 5, 6, 7.
Jackson. We're a little light on Dems. We're light on Democrats.
Okay.
Got two.
Can you substitute?
Hebert's here.
He absolutely can. Okay.
Okay, I'll put Herbert on. Steer.
Okay.
1, 2, 3, 4. Yep, okay.
All right. Let's just go full steam ahead. All right. Okay. Anybody would like to make the motion about to pass?
So moved.
Okay. Second by Representative Spear. Moves on to pass. Any discussion on the motion? Seeing none, all those in favor, please raise your hand. 1, 2, 3, 4, 5. How about you? 6? Yep.
Yeah.
6 is it.
6 up.
Okay.
Okay. It's supposed to be a amendment.
Okay. Next one is 121, and we have an amendment.
It's supposed to,
Right.
okay.
Have you guys seen this? Number 1945? No? Sure. Let me take the rest of the file. Okay, do you guys want to explain this amendment?
Good morning, Mr. Chairman. Jennifer Smith, Legislative Director for the New Hampshire Insurance Department. So what Amendment 1945H does is just further clarify some concerns that were brought to us by the carriers, just to basically make sure that the notification regarding Medicare Advantage plans did not preempt federal notification requirements. So the original bill in sections 2 and 3 had 120 days written notice, and we've scaled that back to 90 days written notice so that it aligns with federal requirements. And then in section 3, we just struck out the federal CFR that was specifically listed because there was some confusion if that was the correct citation or not. Just striking it out clarifies it. We don't actually need to put the direct citation. It clarifies it, just so that if any Medicare Advantage plan needs to give the department 90 days written notice if they're going to cease offering. And that's it.
Great. Thank you. Any questions? Anybody have any questions? Guess we're all set.
All set?
Okay, any discussion? Well, let's see, here, we'll take a motion. I'll move out to pass
Second.
on the amendment. Amendment number 1945.
That's a good year. The war round.
That's true. Okay. Okay, move by Hunt, Saxton. Okay, any discussion on the motion of ought to pass on the amendment number 1945 for Senate Bill 121?
I have a question.
Yes.
Why are we seeing this?
Because this past year, we'll have an insurance company we won't name decided that, but it was my my Advantage plan, decided that they would pull out of the state, and it seemed somewhat orderly, but that the reality was, I have to admit, I was making phone calls and everybody was shocked and awed. So what we're trying to determine is that when a company has decided that they are not going to stay in the Advantage market, they need to notify the insurance department, and this is 90 days prior. The notice is, it's just so that when someone like me who had this happen, if I call the insurance department, they can explain to me that yes, it's true, they're pulling out.
Okay.
Further question.
Another question is, was it a difficulty, or, I mean, how many hoops did you have to run through in order to replace it?
Well, if you might remember when we had that other Medicare Advantage bill,
Yeah.
a lot of people get very stressed out over their Advantage plans. And so, and the fact that you have to sign up every year, it's not an automatic renewal. It's that it creates stress for people because now their lives have been disrupted when someone pulls out, because now they have to go through that whole process to figure out which is the right plan for them.
Okay, so you didn't have wasn't a big problem for you, but I'm wondering if there
I was a
s-
big disappointment. Yes, I was very disappointed that they pulled out. But in terms of let me say, given that if you're over 65, you're probably used to that between starting November 1st and going right into December, your mailbox is overwhelmed with all these people
Medicare Advantage.
who want to entice you
an
to come into
advantage program?
be the Advantage, right? So, and as you may remember in the public hearing, some people called it disadvantage.
Could be.
So that's why it was stressful for people. So, all right, any other questions? All right, seeing none, the motion is ought to pass on the amendment. All those in favor, please say aye.
Aye.
1, 2, 3, 4, 5. Oh, so is he?
Sure, she is,
Yeah,
yeah.
he is there. Okay, great. So that'll be 7,
You got 7.
because Herbert's replacing Gibbs
Herbert was a sub.
for Gibbs, right?
7-0. Okay.
Okay, so let me just.
20 feet.
Okay, now the motion is ought to pass as amended. Is any discussion on the motion? Seeing none, all those in favor, please say aye. Aye. Those opposed? Are you okay with voting ought to pass as amended? Yeah, okay. So, pass 7-0. So let me just put this. Percent, Jackson, Miles, Herbert, Spear, and Sharasa. Okay. Okay. Next up, do you want to do these?
Sure.
Okay. All right. Continuing care retirement communities. This is another department bill, is that correct? Okay, any amendments? All good? Okay, why don't you remind us what this one was about? Do you mind, Jen? Or I'm pretty sure I remember, but
I'm Steve Nottinger. I'm an attorney at the insurance department. The continuing care retirement community bill that you have is a rewrite of an existing bill that was approved in 1989. It's designed to modernize the bill and also add protections that we've deemed necessary based upon our experience with CCRCs. One of the things the bill does is it provides an early warning system when CCRCs are going to potentially be in financial trouble by requiring them to report quarterly their financial status to us. It allows us to act quickly if they run into some sort of financial problems. The bill also gives broad rights to CCRC members. It creates a Bill of Rights for CCRC members. And those rights are designed to give them not only a sense of purpose in the CCRC, but also to the extent that the management acts in a way that curtails their rights, they have the ability to bring an action with the insurance department and ultimately with the courts if necessary. The bill also clarifies many issues that have come up with CCRCs regarding entrance fees, regarding the ability to remove somebody from the CCRC if they're a danger to themselves or others, things like that. But overall, the bill really just modernizes every section of the provisions that were adopted in 1989 and brings them into the 21st century.
okay, great. Any questions from anybody? I have to admit, I was here when this passed. And my memory was these insurance is basically, again, solvency
Right,
of the entities, which is
right. Because people
a
pay,
good word that we know today.
yeah, people pay a lot of money up front, and we want to make sure the enterprises have the ability to pay them back when they either die or leave. So there's a broad range of tools we have under the law to make sure that the CCRCs are solvent and stay solvent.
Okay. Alrighty, so Representative Miles, seconded by Representative Spears, moved ought to pass on the amendment. Oh, excuse me, ought to pass on the bill. Excuse me. Oh, I'm sorry. Okay. So you don't want to do this one then? Okay. So I'll make the motion. Okay, ought to pass on this 124. Any discussion on the motion? Seeing none, all those in favor, please raise your hand. 1, 2, 3, 4, 5, 6, 7. Okay.
Oh, yeah, PDM.
Okay, 247. Okay, citizen members that refuse to dispense. So this bill,
There wanna be an amendment on this?
yeah, this one we had some lot of struggles with. Yeah, Representative Spear.
And you mentioned we did have struggles with it, and there were things people wanted to change, things people wanted to add. So at this time, just at this time, that we retain it for now, so we can straighten it out, because it needs to be straightened out.
Yeah. Okay. Are you all right with retaining it, or you want to?
I want to make the motion OTP on 247.
Yeah, but we know there's problems in this bill. I mean, it has to be amended. It as it is, it was definitely. I mean, the having this new entity that never the Pharmacy Service Administration Organization, throwing them under the Consumer Protection Act, is extremely problematic.
So if the option is retain or
Retain, yeah, that's what we're talking about, retaining the bill.
Well, that is the motion on the floor.
You just
Retain.
made that motion, didn't you?
I did.
Okay, did I have a second on that retaining? And a second. Okay.
okay, just to be clear, so
You want it.
I wanted to make the motion OTP on 247,
Right.
just
So,
for the record.
just for the record, you did want it. I have evidence.
Thank you.
I have the evidence that you wanted to make the motion on passing it. Are you okay with this, or you think we should not retain it, or how do you?
I'd rather retain it than ITL it.
Yeah, no, I don't. Yeah, we're not talking about IT.
If we're,
Right, Representative Herbert, did you have a?
if we do retain it, and it looks
Yeah.
like we're going to, is there a period of time to this session in order to
Right.
make some?
So, what we would do is in September,
Yeah,
and we'll all be in our new digs. Over. and
up the road a piece.
up the road a piece behind the cemetery. And we'll take it up, and we have to have it out of committee by end of November, November, and then it would then hit the floor, House floor, in the first week of January.
Okay, thank you.
Okay. All right. So the motion is to retain. Is the question clear? All those in favor, please say aye.
Aye.
1, 2, 3, 4, 5, 6, 7.
And who was it?
And it was moved by Representative Spear
Second.
in tax instant. Okay. All right, so now we're down to the pool risks bill. So having reviewed the hearing, it's clear that where I was coming from, and that I think that this legislation, we want to pass something, we want to address this problem, but that I think at this point in time, we would, I think it makes sense to, no, we're not retaining this bill. We want to pass this bill, and I think it makes sense to move this to the insurance department from the Secretary of State's office. Well, no, I'm saying pass, that we want to pass something. Okay, we want to pass a bill
But not necessarily this?
Not necessarily this bill, because this bill is under RSA 5, which is
Right.
the Secretary of State's office.
So do we have something? We're
So-
not doing it today.
To not, what I would like to do is get a consensus from the committee, the Health Insurance Committee, is that is the way we would go, and that then I would hope that I could have something for you next week.
I would move on to pass on 297 also.
You just want to pass it, okay?
Yes.
But how do you feel about moving it to the insurance department?
No.
Okay. Fair enough. Everybody else? Everybody else?
Move it.
Which video are
I
talking right now?
think this so clearly belongs in the insurance department, it boggles my mind that it's not.
Okay.
I kind of feel the same way. I second that.
Okay. Okay.
I heard that.
Well, I mean, it is self-insured, if you can call it, in terms of that. Okay.
And that is, the ERISA is monitored by the insurance department.
No, actually, ERISA is federally regulated, and we, the state, have no control over ERISAs, right? So that's why that sort of being problematic calling it that. I mean, in terms of my history of the subject matter, and was that the original reason it was put under the Secretary of State's office way back then and not on the insurance department was that no one ever, it was never, solvency was never the issue. Solvency was never a problem. No one ever thought that a risk pool would be insolvent, because it basically it's member driven, so it's a member driven entity, and the members set their premiums based upon what they're going to need to make it work for that, theoretically, that year. Obviously, you have the lapse between years, but that it's a member driven entity. And as far as I'm concerned, the reason why it was put under the Secretary of State's office is because that's what they do. They register businesses, they register entities, but there was never intended that it actually needed any government oversight, and that occurred in 2010. That legislation occurred in 2010, where it came in. And yes, I was in the room when it happened. It was a non-germane amendment that Bill Gardner had brought in. It was brought in at the committee of conference level, so it never really had a public hearing or had any discussion. And that at that point, it was then to try to make sure that there was some kind of government oversight over these risk pools, and that it's been set on the books since 2010, and then more recently, then it became, I guess, thanks to COVID, where we all of a sudden nobody was going to the doctors, and suddenly their reserves got very high, and the Secretary of State's office had made a decision that under that authority that they had that was given to them in 2010. That they should order them to give rebates. And the only reason I was aware of rebates at that time, obviously because I'm not a school district or a town, is that I had Delta Dental. And Delta Dental, all of a sudden, and I was very surprised that for 3 years, their premium was flat, just the same premium. Didn't change at all. And that was actually, it turns out, that was an agreement with the insurance department because of their reserves being too high. That was decided that they would lower their reserves just simply by keeping that premium flat. Because sure enough, after COVID, everybody started to go to their dentist again and get their teeth clean, and so certainly that the and I would say this past year they did raise the premium. It did go back up for Delta, but and notwithstanding that seemed like a very orderly way done, and that was definitely done by the insurance department.
So, although we totally understand the intention of the Secretary of State and they do a great job, we feel that the insurance department is better equipped to monitor they have the tools, the resources.
When it comes to solvency, that is their whole purpose.
And this is definitely an issue that we need to address, the solvency, because we cannot.
That
we
is the
have to
purpose
make
of the
sure
bill,
that
is
these
solvency.
risk pools
Exactly.
become insolvent, which I believe two have. There's definitely broad implications.
Correct.
So the first issue is pursuing moving it to the insurance department, and then second, really work through some of the details.
In terms
on
of,
the
yeah,
bill,
in terms of how they would make sure
right,
we
and
don't have any
removing
more
some of the
insolvencies.
hard-coded percentages and amounts,
Correct.
removing them out of the legislation.
I mean, in terms of, those dollar amounts, I know that the insurance department has a process. Whether we put them in as guidelines or put them in that,
As
we
rules
can
or
certainly
something?
have that conversation, Nick,
All right,
next
thank
week
you.
when we take up an amendment. So how do you feel about that?
So there would be an amendment?
Amendment next week.
Okay,
You okay with that?
yes?
Okay. Representative Herbert?
Don't want to extend this conversation, but as you referred, there's a couple of fairly serious bankruptcies going on right now. So I'm just wondering, or somebody can answer the question, what role is this change going to?
Well, this is going to hope that the one big one doesn't go bankrupt. That this legislation would make sure that it can
could
be
roll
solved without a
into it.
bankruptcy. And certainly we think we'd much rather have a department agency who has the authority to get in, step in and work, get solvent, make sure they stay solvent, rather than taking them to court, which is what's in the bill.
So the answer is yes. That's why we're doing it.
Exactly. Representative Miles?
Yes.
Your opinion on this subject matter?
What's the specific question?
Well, the specific question is that should we put this up next week to have an amendment that would put it under the jurisdiction of the insurance department?
No.
Okay. You think we should keep it at the Secretary of State's office?
Yes, it's their actuaries that found the problem, not the Department of Insurance.
No, the Department of Insurance never had anything to do with it.
Right. And
It was their Secretary of State's office.
there are several
actuaries.
things that the Department of Insurance is not.
Do you think the
That's
Secretary of
that.
State would do a better job of solving this problem?
I think we should move OTP as is.
Okay. Representative Shreeson?
I think the oversight should be at Secretary of State.
Oh, you think it should stay at the Secretary of State's office? Okay. All right, so at this point, if I take the straw vote, we have 1, 2, 3, 4, 5 for an amendment and 2 against. 2 would just assume leave it at the Secretary of State's office.
Yes.
Okay. So I will take that as a straw vote to go forward. Now, having that said, I will ask anybody I don't know if anybody wants to make a comment or discussion on what they think we should be doing with this amendment. Please free to let us know you'd like to speak. Dave? Yeah.
Thank you, Mr. Chairman. I'm not going to repeat the testimony that I gave the other day, but I will say that we have legitimate concerns with the way a couple of the risk pool organizations have been operating. One of those, as we expressed the concern early on, did in fact go insolvent, and they are now under receivership so that the business matters affairs of that organization can be distributed. We also proposed an amendment at the last hearing that we passed out. I have extra copies here. If the committee
And we
would like
got
to see
another
them.
amendment even today from Senator.
I'm sorry.
Yeah, Senator Carson gave us another amendment. I think we just got another.
Okay, I don't know that I've seen that one,
Yeah.
but the bottom line is this, is that there's been a lot said about what this bill will do in terms of, changing the fundamental operations of these organizations. We are concerned about the people that are affected by these organizations. Those are the employees of political subdivisions and the taxpayers of political subdivisions, because they're the ones that are footing the bill for these organizations. And it's important that they remain solvent so that they can provide the services for which they are intended. There has been a competition going on between pooled risk organizations that have caused some of the organizations not to follow the actuarial reports that they have been given by their own actuaries, and they've tried to control the pricing through guaranteed maximum rates that are below levels that should be charged to make sure that those organizations remain financially healthy. All this bill does, puts in guardrails in terms of a minimum threshold and a maximum, so that these organizations have enough in reserves to remain financially healthy, to the point that there's a very small chance of insolvency in any given year. That's what the bill does, and really that's all the bill does. We know through our actuarial review that NHIT was in serious financial trouble, and that pooled risk organization went under. We also know that over the past few years, Health Trust has been well under the area that they should be, to the point that the risk of becoming insolvent is higher than it should be. That's not to say that they are going to, but there is a greater risk that they will, because of the amount of, I'll say, low reserves that they currently have. So what happens if this bill does not pass? It's the status quo. And my office will, engage in the enforcement actions that may be necessary under this bill. And when we have been through this in the past with the same organization, Health Trust, it has cost the taxpayers a lot of money, millions of dollars in legal costs, lobbying costs. It has gone up to the Supreme Court. And in every one of those instances, Health Trust lost those cases. So what we're suggesting here is not some pie in the sky theory. These are areas that we are legitimately concerned about, that we have taken on in the past in different areas, and we have been successful in the conclusion. These are pooled risk organizations are self-insured organization, meaning that the members are the organization. And if their reserves drop to the point that they can no longer pay claims and the reserves run out, those member organizations are on the hook to pay the claims that have been encumbered. That's a problem, because those communities are going to have to either tax their citizens to raise those funds to pay for those bills, or the group is going to go to the state. They're going to come to the legislature and say, we need help with a bailout. We don't want to see that happen. This is a fundamental tax issue in the state of New Hampshire, and we want to make sure that we protect the taxpayer dollars in doing this. So sending it to insurance is a discussion that we can have down the road. But right now, there's an issue that needs to be addressed. You can't just kick the can down the road and not do anything about the underlying problem that we see here that really does need to be addressed. So that's all I have to say, Mr. Chairman. I don't know if there are any questions from the committee, but
So you agree with me, the problem is solvency?
we need to make sure that we reduce the risk of insolvency to the extent that
Right.
we can.
Right, so it wasn't, in terms of when the whole reason why it wasn't regulated from the insurance department way back in 86 was solvency was never an issue. That everybody says it's not insurance.
Well, my understanding about the 86, 87 statute that created pooled risk organizations were that these organizations were created without any legislative authority to do so. And the insurance commissioner at the time raised the flag saying, you know, what are these things? Who's regulating them? And, you know, what, I mean, there was a big liability at the time. So the legislature created the pooled risk law to allow them to exist as self-insured entities made up, you know, by political subdivision members.
Right. But the assumption why it was never put under the insurance department regulation, it was because solvency was never a concern. It was just about can they exist, and therefore it was given to the Secretary of State's office because that's what you do best is register businesses.
Well, but I don't know what that discussion was, but these entities are not regulated by the insurance company. That's right in the statute. And they do receive a tax exempt status because they are quasi governmental entities because they're of their makeup.
Right. So when it comes to dealing with a solvency, with an entity it has a solvency issue, are you telling me that you really believe that it's better to have a RSA that has a number there that is created by the legislature, which has no experience and no knowledge and doesn't know anything of what they're doing, but they're putting a number in statute, versus having a department that its whole 120-year history is built around solvency? Wouldn't it make sense to give it to that department to sort through this to make sure that they don't have the financial problems going forward?
I have said repeatedly that I am open to the subject of, you know, who should administer these organizations. Maybe insurance is the best place, but I think sending it there would fundamentally change how these organizations operate, because the safety valve for solvency among insurance companies is the pool that the insurance department manages. You know, that is a fund that is used, you know, to address that. And insurance companies pay a fee to the insurance department for that supervision. There are no fees that are paid by pooled risk organizations to the Secretary of State's office. We oversee our obligation through funds that are existing in our budget. So
In the securities division,
securities are
right, which didn't even exist back there in 86, 87.
Yeah, probably not.
I know, I was in the room when that got changed too.
So, bottom line is, you know, our interest is in the members and the citizens that live in those communities, taxpayers
Right.
and employees.
Well, we
And
certainly have gotten a lot of letters from the members, and they all clearly told us that they think changing it to insurance is a good idea.
And I think there's been a lot of confusion out there as well. And some of them are panicking based on things that they have been hearing that are unfounded, because this bill.
Well, is it unfunded? Because aren't you telling everybody that they're at risk of going out of business?
There is a higher risk than should exist. I have said that, yes.
I have a question.
Yes, Representative. Well, I actually Representative Spear had her hand up first, but you could be
Okay.
second.
Based on what we heard during the committee meeting, it sounded like, let's use Health Trust as an example, because they're one of the oldest. They were absorbing the risk, even though the statute says the members have to absorb the risk. And the amendment that we have in front of us says that the members have to absorb the risk, even though Health Trust has been absorbing the risk for 37 years.
That is not what the statute says.
No, I know that the statute does not say that. Well, it does say that the risk is being absorbed by the members. I read it.
The risk is with the members that make up the pooled risk organization. The pooled risk organization does not assume the risk for the members. When the reserves run out, the members are on the hook for any expenses that are
I
left.
understand, but in the case of Health Trust, as an example, they have been solvent and they have been mitigating that risk for 37 years, acting like a regular insurance company would do. It seems to me that they have been successful, except that they have run into problems that the insurance department could have helped them with. I'm not clear on why we want to take something that, I don't know where to go with that question. I think I
Well,
just
I mean,
have
I-
to say something, you know,
Well-
it's been working for 37 years. It belongs to the insurance company.
But I
They've
would
been
say,
acting like
I
an
would say
insurance
Representative
company.
Spear is, and you can tell me if this is true or not, that you ordered them to give $40 million rebates.
In the,
Do they have $40 million?
so there was an issue back in the early 2010s when pooled risk organizations and the Health Trust in particular were holding large reserve levels. It was surplus money that they were holding on their books. Those are taxpayer dollars. And so
But
the issue,
but that you just admitted, there's taxpayer dollars, but these organizations were operating and that they were ever assumed that whatever they did, they were okay. They didn't need to be regulated.
so the court said that when you have surplus money way above and beyond what you need for reserve levels to pay claims, then you give it back to the cities and towns. The pandemic hit, and people weren't going to the doctor in the early years, so those reserve levels went up into the surplus range. It was not the Secretary of State's office that said you have to return that money. There was a resolution passed by the board of directors at Health Trust that said we're going to give that money back to the cities and towns so that they can use it to cover expenses related to the pandemic. And there's a record of that in their minutes. They were not forced to give that back by the Secretary of State's office.
So it was a bad decision by the board to give that money back.
Well, I think it was contrary to their actuarial recommendation.
So the actuarial told them that, oh, by the way, everybody's going to start going back to the doctors after COVID is over, and you probably will need that money?
I believe the recommendation was that they were informed that there is going to be an increase in claims. You need to prepare for that.
And did you tell them that?
We did not tell them that, no.
Well, you
No.
had did
So
you have the
that-
regulatory
so
authority
that
to
was
tell
a-
them that? Because the insurance department would have. The insurance department told you, no, you can't, don't do that. That our actuarials show that you're going to need that money. But you didn't really have that actuarial help until after the fact.
Well, there's probably people that are more knowledgeable on actually how this transpired than I do. So I'm not going to try and, talk about how that worked, except to say that we got more involved. And the reason that this legislation was generated was that Health Trust came to us in the spring of 2023 and self-reported that their reserve levels were dropping to a level that was concerning. We learned after the fact that by the end of June, by the end of the fiscal year, they were down to about 10 days of operating funds to pay claims, which is really, really tight. They've bounced back a little bit since then, but they're not out of the woods yet. And this bill is designed to, create those guardrails so that this does not happen in the future. And that's it.
But you said this, that you're okay with willing to eventually move it to the insurance department.
I said that we can certainly have a discussion on which state agency is appropriate. It might be insurance, but
So wouldn't this be a good time to have that discussion?
I think we need to solve the problem
Well,
before we talk about where it goes.
Yeah, but that would means that you have a baseline to say, well, once they've gotten the reserves to a certain dollar amount, then we're willing to talk about changing how we regulate them. In other words,
That's
would
not
you
what I'm saying
sunset,
at
or
all.
we want to set a
What-
date when we were going to have this conversation, or are you just saying you want to have a conversation, but at the end of the day,
No.
you'll never think it's a good
No,
idea?
what I'm
for the
saying is
insurance
that
department?
if we pass this legislation as we would like to see it amended, that I think the need for, intrusive oversight goes away. And I think that, we can have that discussion then, once that's fixed. Is it better suited to be placed in insurance or some other agency, remain with the Secretary of State? But at least the problem has been addressed.
So you're saying that insurance department is intrusive oversight?
No, I was not trying to imply that. I'm just saying.
Well, that's what I
People-
thought you said.
People have taken great exception to the fact that we're trying to do something with this problem. Some people perceive that as the Secretary of State being intrusive. I view it as doing our job. And we've raised the issue to the legislature. If it's up to you, as the body that makes these decisions to set policy, believe
Perfect.
this is a good idea or not.
That
but
we both can agree on.
it's in your hands, yes.
Chairman,
Okay, Representative Teresa.
So I think we all agree that there is a need to have guardrails. There is no question on that. The issue I'm hearing that you feel that the Department of Insurance is better suited to handle this oversight versus Secretary of State. I'd like to get more information from you. Why do you think Department of Insurance is more equipped to do this? And second question to you would be that, do they have anything in place at this moment to have those oversight? So I'd like to get the information from
answer
you.
to that question is yes, yes. Yes, the whole history of insurance, the statute, the whole reason it was created in the first place 120 years ago was the issue of solvency. We wanted to make sure that that insurance entity, that whether we want to call them a risk pool or an insurance entity, that entity has the reserves, key word, has the reserves so that they will make the payouts to satisfy the claims that they are providing the product for. That's 120 history. Now, you asked me, do they have a system to view? Absolutely. They have perfected this system over the last 100 years to have a system to monitor it. We don't have to go to out of state to get auditors. We have the actuarials. We got 3 on staff, and they are intimately aware of what's going on in the health insurance market. Okay.
So if that's the case, yeah, as I can understand from you that they already have been doing it for the last 120 years.
Right.
If that's the case, then why we are in a situation where there's a requirement now to put guardrails? Why there is a situation that the
Why now?
case of insolvency is happening?
Because we didn't have the insurance regulator. The regulator was the Secretary of State's office. That the only way they can regulate them is by statute. They don't even do rules.
Mr. Chairman?
Yeah, Representative Saxon.
Representative Chirasso, perhaps it's unclear to you. The problem is that this is in fact health insurance, but for various reasons that have been gone into beyond anyone's level of further interest in 1986 or 1987, it wasn't placed with the insurance department. So all of the things that you're asking, which are perfectly reasonable, are in place in the insurance department. And this is why those of us who advocate for moving it over to insurance and taking it away from the Secretary of State's office want to move it there because it's insurance. It happens to be insurance for public sector employees. And so that was created its own special class, but it still has the problem of regulation. And all those guardrails up and down are much more effectively handled, in my opinion, and many other people's opinion, in the insurance department, which regulates insurance except for these pooled risks, which is a fancy name for health insurance.
I still have a question.
Okay, you feel a little better? You want to think about it a little more? And
Yeah, I probably think about, again, the same question comes that if everything is in place from the insurance department,
it was never in place. That is what I am proposing for an amendment for next week, is to put it in place at the insurance department so
So that-
they can use their skills that they have refined over the last 100 years to ensure solvency.
so the insurance department was not handling this.
At all. Nothing. And I'll tell you, in 2010, that I voted against this last minute amendment that gave the Secretary of State's office more authority. I voted against it because I kept saying this is in the wrong place. They're not geared to be doing this kind of work.
Okay.
This insurance department work. It's always been insurance. But
So at this-
obviously it was not at
So
that point.
at this point, I would also like to hear from the Secretary of State office that why do they feel that they are better suited to handle this?
Fair enough.
Can you answer that? If
We've been charged to, with the oversight through statute. I disagree that this is an insurance product. This, I mean, the pooled risk organizations are designed to provide health insurance
Don't use the word insurance.
through being self-insured, but they contract with insurance carriers to do that job. They're aligned with Anthem Blue Cross or Blue Shield, or they're aligned with Harvard Pilgrim, and they collect the money to pay those companies for the insurance plans that they are then offering for the pooled risk organization. So, state of New Hampshire employees are self-insured through the state of New Hampshire. City of Manchester self-insures their employees. Nashua does the same thing. What RSA 5B does is it allows smaller communities that are not large enough to be able to go out and get good rates on insurance products to join together to create a critical mass so that they have that buying power and they can get quotes and hopefully lower rates on providing that insurance. That's what they do. They are not actually engaged in creating the insurance themselves. They do not assume the risk that an insurance company does. If the claims are higher than the rates that they charge. These are just political subdivisions that join together to create a pool large enough so that they can go out and get competitive rates and save the taxpayers money.
Okay, Representative Herbert.
Is there sufficient money anywhere in order to write this vote? Yes or no?
Is there sufficient money to
Pay off you've got a money problem. I call it an income problem, and I was, so I don't
So
know if
the-
you were here when I did that.
I mean, the short answer is yes, there is. And so, the actuaries for these organizations calculate what they expect the rate of claims are going to be. And based on that, they assess rates. And then in addition to that, they create a reserve level that is held by them so that if there is an event or higher than expected claims, they have this reserve pool that they can go to then to pay them. What has happened in the case of Health Trust is that the reserve level has dropped to a rate that is much lower than what is called for in the legislation that is being proposed. In fact, the range, the threshold is within the levels of where pooled risk organizations have operated historically. And so they're reasonable from that perspective. What will happen is that the pooled risk organizations that have low reserves are going to have to build them back up so that they're in a position to be financially healthy. If they do it in 1 year's time, it's going to be a shock to the taxpayers and the employees that foot the bill for that. They can spread that out over a period of years, but the rates are still going to go up. And our actuary has predicted that if this bill does not pass, that over a 3-year period, health trust rates are going to go up 40%. And we provided that in the documentation that we've given to the committee in the past.
Mike, I think I'm following you. And what I'm hearing is if somebody came in and said, okay, give me the money or you're in trouble. And the answer would be, well, we don't have that money. We can, over time, maybe catch up. And whether it's the insurance department or your department that's responsible for it, what I'm hearing is that when it comes to this health, what's the name of it? Health Trust. Health Trust. It's broke. And as you said right out, the members are going to have to pony up more money, and that makes a lot of sense to me. But the problem is the people didn't put in enough money in order to cover things, and so as a result of that, now the taxpayer is going to have to do it. And my final question is there anything anywhere that would allow the state to raise taxes enough to put an end to this problem, and that's it? Now, I'm not thinking that's all that fair.
But that's a would you believe question.
Would you believe?
Yes.
I
that
think
you think that.
that's a tough. That's
Right.
a tough.
Well, in this case, it's the local property taxpayers who have been paying in the fund, and I guess use another one of those great little political things that you love. What they really need to do is do a clawback and get that $40 million back. They shouldn't have paid it out.
Okay, where's the club? That's going to be an assessment on the people who have the program.
Investment on those cities and towns who've been paying the premiums.
Okay,
So-
I'm not saying that it's obvious to me. My point is that we kind of have a problem.
We
in
have
wanting to
a
pay
problem,
bills.
and we will pass something this year. We are not killing this bill, and we're not retaining this bill. We are going to pass a bill that we think is the right answer to get these entities back on ship shape, get it so they're floating right, and have a proper oversight. Representative Miles.
Thank you, Mr. Chairman. Thank you, Secretary Scanlon, for taking my question. Thank you for your team for doing all of the hard work they've been doing. Would you say at this point in time, your department is best equipped to continue to perform the corporate audits of this nature, considering that you are the corporate audit division that found this problem in the first place?
We're well equipped to do this job. We've been doing it for some time now. We have our own in-house staff, but we also have outside experts that we use.
Thank you.
Representative Teresa.
So actually, I have one last question and also a concern that usually, if you are thinking towards allowing the insurance department to do this oversight, won't it be a conflict of interest? Because they are the one managing the risk pool and insurance?
They're not managing it now. The risk they're managing right now is the Secretary of State's office. They're the manager of the oversight.
No, I'm talking not the oversight part. What I'm saying is that the risk pools are basically at the end of the day the insurance companies.
No.
Or
At the end of the day,
self-insured.
the risk pools are cities and towns that have come together and join, like in a RISA, like in a self-insured plan, and that they are instead of they're all just they're mostly they're cities and towns and school districts. That's who they are. They're the ones who are operating. They're the ones who sit on the board. They're the ones who got themselves financially troubled because they thought they were ordered to give that $40 million rebate. They whatever missed decisions was there. That was their decisions, and the reason why this was never treated to be something that needed to be monitored is because they are self-insured. They're doing on their own. In other words, this is the people who are benefiting it, the people who are paying for it. All the people are all the cities and towns.
Okay, so the conflict of interest doesn't
There's no
arise there.
conflict of interest. No. One more. Yep.
And thank you, Secretary, for raising this very important issue. But I just want a clarification again on Health Trust. Did I understand correctly that they came to you in 2023 to say we're in trouble, as opposed to, you reaching out to them to say, are you, what is your solvency status? So I guess that would be my question is, are you doing this proactively or reactively? Once there is a issue identified by the pool risk, that they come to you and then, you take the appropriate action?
They came to us in this case, and we do monitor what's going. We get financial reports from all of the risk pools, and I will say that there were 4 up until NHIT became insolvent not too long ago. The 2 others are Primex, which is not healthcare, and then school care, and both of those are fine with this bill as we would like to amend it.
I think that is my concern, that we already had 2 become insolvent. And I'm not sure the mechanics of why, maybe your office wasn't more proactive in realizing that they were in that much trouble. I don't know the history behind it. Does that make sense?
I think your question makes sense.
People that do reserves have 100% accountability. They did not do their job. That's not anyone's
No, but if there's
their own. There were bad actors, which thankfully mostly there are not, but there were specifically these bad actors who did not act in good faith, and that's why Health Trust got into the position they were in. And how do I know that? Because this is my field of expertise, Carrie. So that's how I know that.
If you don't have data, then you can't say something.
I respectfully disagree with you.
But there's several there's not that many of these pool risk entities. And we had 2 that went insolvent, 1 that is in trouble. So that's where I totally agree we have to do something, but that's where I'm struggling with being more proactive and making sure that there are mechanisms in place that will make sure that these other ones are protected.
Can the state float a bill to pay the bills, a bond, and then they can work it off?
I think it is clear that the entity is big enough, the amount of cities and towns involved is big enough that they can work themselves out of this problem. It's just that what we want to do is going forward, we want someone who monitoring it on a day-to-day basis and not doing it by statute, and then that a certain report comes in and they well, we're going to have to take you to court. Okay, it's doing it by statute versus doing it by rulemaking and having a department that is integrally going to be involved on the day-to-day operation so that they get this problem solved.
So you're favoring rulemaking?
I'm favoring rulemaking. I'm favoring the Department of Insurance to do rulemaking. Exactly.
So is my assumption correct that at this point, these entities or trusts, they are monitored by or they are managed by Secretary of State?
That on the current statute, that is correct, that they're filing reports and they're doing their due diligence to the Secretary of State's office. But Secretary of State's office, is using the Securities Division, which is a whole different animal. We didn't get into discussion of that, to be analyzing what these numbers mean and how they're making their business decisions. At the end of the day, yes, it is important that the actuarials are right. We all hope the guys with the green shades do a good job of predicting what's happening in the marketplace and what's going on, and knowing and having their ear to the ground, and that's exactly how insurance operates.
So,
That's
so
why-
if I may ask the same question to you, Secretary, that usually, if you are managing the entities, isn't it more efficient to have a different company or different department to do the oversight part or putting guardrails? Because if the same company is managing and at the same time, usually the oversight departments are, if it's separate, then the oversight becomes more effective instead of putting the oversight with the same company or same department who is also managing it at the same time. So do you agree with what I say?
In the case of risk pools, the statute envisions them being the member political subdivisions that are responsible for their own oversight. And that's the way it should be. There should be a strong board of directors that really represents the communities, that understand, how the claims process works, how they set rates. And if that is working properly, there really should be no issues. And the Secretary of State or any entity that is responsible for the oversight would then just have a global view and raise the warning flags when they see something like we're doing right now. And I think that's the way the statute is written. I think that's the way the pooled risk organizations would like to run. And, it's just necessary for somebody to step in when there is a significant problem that needs to be addressed.
Okay.
Representative Spear.
One of the problems that I heard as a result of the first, the meeting we had before, was that Health Trust was saying that they need to have reserves higher than what's in that statute in order to keep things on an even keel, and that's what they're working towards, a higher level of reserves, whereas a maximum that's in the proposal is lower than what they think is right. So then the question becomes, I guess, where is the data that says it should need it, that having it lower is applicable? Where is something that says that is the right thing to do? The insurance company has the insurance department has a bunch of actuarial tables and processes and everything to figure that out. How are you determining that it's so much lower than what Health Trust says that they need?
We have our own actuaries that we hire for this purpose, and they're the ones that have come up with the suggested range. When you look at the range that is proposed in the bill, along with the amendment that we propose to have an additional amount for assessments if they drop below a certain level, and that amount would be used just for that purpose, the range, it gets quite a bit closer to where they want to be. And it's just, you have a question?
Just building on what you just said, life changes, everything changes, especially impacting by drugs and all kinds of things that's happening in the market. And what we have in this bill are fixed numbers. They're not alive, if you will. And that seems to be very dangerous. It means that the only way we can ever fix anything for the future is to write another law. And that doesn't, whereas the insurance department works very differently. And that seems to be a much safer approach. Is that the plan? I mean, is that what you plan to do every couple of years, changing the laws and stuff?
What our actuaries have told us is that if we use the ranges here, that it should be pretty stable. And that from time to time, they may have to be revisited, but they are at a level that would have a minimum risk of a pooled risk organization going insolvent in any given year.
Then why is Health Trust saying it's not good enough? We're stuck in the middle of this, right?
Yeah, well, obviously we have a difference of opinion with Health Trust, and in the past they have a history. When you go back to the early 2010s, I mean, they were holding huge amounts of money that were surplus. Again, those are taxpayer dollars that could be used by communities to pay for the services that they need, as opposed to just being stagnant in a pool above and beyond what was necessary to run a pooled risk organization. So there's going to be some tension there between the agency that has oversight and the organization itself. But with cooperation, there can be a balance that's achieved, and I think that this bill does that.
Representative Miles.
Thank you, Secretary Scanlon. Can you confirm that the Department of Insurance is funded by the insurers?
That's my understanding, yes.
So maybe that's a conflict of interest.
Okay. Thank you very much.
Thank you.
Well, that's one thing I was asking, conflict of interest part.
So, is there anybody else who interested in speaking? Okay, so we will have an amendment for next week, and then we can.
Can you summarize the amendment for next week, please?
The amendment of next week would be to attempt to do what is in this current bill in terms of setting standards and expectations of what solvency should be, but that the actual implementation of those regulations would not be done by statute. It would be done by the insurance department, by rules in the insurance department. So rulemaking process will then thresh out what is the right numbers.
Have we spoken to these entities where they want to be, where the
They have
preferred-
spoken, a lot of those letters and mailings you're getting
No, no,
are from cities and towns. And he was saying that they're taxpayers' money, but in this case, the taxpayers' employees, which is cities and towns, and usually a lot of them are, whoever's in charge of the finances of the town or the school district, the business manager, they're the ones who sit on the board.
So whom they prefer usually, have we found out to be, whom they prefer usually to be governed by or for this purpose? Do they prefer?
So we
Or they have no
we have
preference?
done a little bit of research from other states in terms of what they have done. We haven't found any that does it by the Secretary of State's office. We have seen a fair amount is done by the insurance departments. But ready for this? A lot of states created a whole new department just to regulate risk pools because they're big states.
California. Big one.
They have their own departments to do just this, and
Yeah.
we're not that big of a
They
state,
screwed it up.
and so that's why that's why we're not leaning that way.
So do you think that
Create a
could?
new state agency.
Yeah, I got it. That's exactly what I was saying. That usually the oversight agency or oversight entity are different.
I would have to say is, and this is
Has to
really
be
this is the one that I'll never forget my going through this process back in 2010, when I kept saying to myself, "Well, this is belonging to insurance, and belonging to insurance." Well, at that time, the issue was again their reserves were too high, and it was fire departments in these towns that had pointed it out that the reserves were too high and that they should be refunding money back or they should be reducing the premiums that the employee pays, because I guess most cities and towns, it's cost sharing. The employee pays so much and the individual pays some, the individual employee. And so that cost sharing, okay, was that the issue was that the reserves are too high, then the employees are paying too much in insurance because the reserves were too high, that they should reduce their reserves. And that was the issue back in 2010. Nobody talked about solvency. Solvency was never the subject matter. It was about the reserves being too high. It's always been that. It just as he mentioned, when back in the earlier days when it was about they're creating a workers' comp plan, it was the reserves were too high, and so and they were using that reserves to help create a new entity. So, which was a controversy in and of itself. But having said that, in terms of why we're in this pickle is because it never crossed anybody's mind that the reserves was
It'll go low.
bit too low.
Well,
And if it did, if they said right out of the block, we need to ensure that the reserve don't get too low, this would have been handed to the insurance department in a heartbeat, because that's what the insurance commissioner.
well, that's the whole point of oversight. Having oversight is because, I mean, if everything goes good, nobody cares. When the
Exactly.
problem start happening, that's when people start caring.
Two have gone.
Now it's the problem. Right. Now it's the problem.
So under the current process, two
They have, technically.
Under
yeah.
the current process, two of these risk pools have gone insolvent under the current process.
Yeah.
So we need to do something different, because we can't wait
Same old, same
to
old.
find out that there's a problem. And we don't need to hire actuaries when we have them on staff that do this on a regular basis, is my concern.
So the decision that we have to make basically is that who is going to do the oversight.
Correct. That's the amendment going to do. Yeah, you're right.
And the concerns are there on both sides. I mean, if you allow the Secretary of State to continue that, then the same issue comes that if it's happening under their watch already, then what kind of process they can put in place better or whatever to have better oversight to stop it. But the other concern, which I just heard, and I also raised the same thing, that if you're handing it to Department of Insurance, then they will have conflict of interest as well, because they get funded by these entities, right?
I'm not sure where the conflict
That's
is,
what-
but Representative Miles is concerned. I get it. I would say, just to humor you all,
So maybe create a new entity.
New Hampshire is different than, let's say, Vermont. In Vermont, the insurance department is fully funded by the state budget. In New Hampshire, it is true that we fund our insurance department through fees and through audit fees, and we have the ultimate. We have if there in terms of if the budget is too high, if problematic, they have an assessment. So we do this for both banking and insurance, that they have an assessment system. So you could argue that the foxes are in charge of the chicken coop. The regulated, the regulator are too close, because that's how the regulator gets operated. But I would say, after all my years here, no one has ever said, boy, I think there's a huge conflict that the foxes or the insurance companies get away with too much here in New Hampshire, because that they are funding the insurance department. So this is a new concept for me to that she's offering up. But at the end of the day, it really doesn't matter, because when you talk about the ERISA, the idea of an ERISA is that a large employer, and he was going through the city of Manchester, talking about the state of New Hampshire, and I remember when the state of New Hampshire decided to go ERISA, because basically one of the reasons why a lot of entities go ERISA is that they exempted themselves from state regulation. They're, one of my stories is when when I had lost a floor fight on another health insurance mandate on Thursday, and then next Monday in the county delegation, we vote to become self-insured. And I looked at all the Democrats who were in my committee, and I said, you just realize that what we just passed last week, you are now exempting the county from having to comply with it, with this vote to become ERISA. I don't have a problem with ERISAs. I would say that you have to remember when they say the ERISAs, and he was talking about how it's taxpayers' money, which it is, it's taxpayers' money, but the taxpayer has given it to the cities and towns to administrate it and expend it and pay health insurance. If we're going to call it health insurance, let's just call it an employee benefit. Okay? You pay that employee benefit. And who's on the hook if the employee benefits are too great? At the end of the day, it's going to be that taxpayer in that cities and town. They're going to have to go back and say, we were underfunded. We need to
Raise your taxes.
raise your taxes to fund it. So the problem in this case, nobody ever thought of insolvency. No, insolvency was never a question. People they'll just raise enough money from the taxpayer. Everything's going to be taken care of. Everything's hunky dory. Solvency was never the issue. The issue has always been surplus.
Yeah.
Okay. And surplus was what got them in trouble with this $40 million kickback. If they could claw back that 40,000 or 40 million, excuse me, if they could claw back that 40 million, then we wouldn't be here. This problem the problem would have been taken care of. But as we heard in the testimony and the problem with that was that they had to figure out how much each individual employees, their co-pays, and how much they had to do a whole fancy spreadsheet for every city employee over the terms of the times over which they're giving the rebate on. It was like a nightmare. I mean, it's just an absolute nightmare. Where meanwhile, Delta Dental, all they did is to simply hold the premium flat for the next 3 or 4 years. Why did they do that? Because that's what the insurance department told them to do.
Smart move.
More taxes.
Okay. Are we all set?
We're done.
We're all set? All right. We're done.